Good afternoon, viewers. I am Praveen Soni, Secretary WIC of ICCI and Company Secretary in Employment by profession. On my behalf and on behalf of the Institute of Company Secretaries of India, extend a warm welcome to you on this 16th session of the Companies Act 2013, Enable, Evaluate and Excel, a capacity building initiative by the ICSI. This initiative is conceptualized by the youngest president and the current president of the ICCI, Mr. Shyam Agarwal. The objective of this initiative is to refresh the knowledge of the members and to deliver an expert commentary and provisions of the Companies Act 2013, along with the practical insight, deliberations on the role of professionals and on the opportunities available to the members of the ICSI. We had already had around 15 sessions on the various topics of the Companies Act 2013, including NCLT, related party transactions, ESOP, sweat equity shares, bonus issues, NCLT overviews and all that. This video conferencing of all the session has been uploaded on the YouTube channel of the ICCI. As the funding of the business is always been a challenging issue for the role of the professional and is very critical just because to guide the management for the good source of funding which will suit to the business. To discuss this issue and the practical approach, today we have scheduled a session on the topic, that is issue of securities, right issue and private placement preferential allotment of shares. To guide our members in details on the various critical aspects of the funding and issue of securities, we have with us Mr. B. Ranganathan. Mr. Ranganathan is currently the Executive Vice President and Group Company Secretary of the Edelweiss Financial Services Limited, and prior to Edelweiss, he was with Tata's for more than a decade. He has 25 years of experience into regulatory and governance function. He had the in-house regulatory and governance function of the Edelweiss also, and is a fellow member of the Institute of Company Secretaries of India and Institute of Cost and Accountants of India. He is already a member of the subcommittees of the Company Law Review Committee 2016 constituted by the Ministry of Corporate Affairs, Capital Market Committee constituted by the CII and Committee for Review of SEBI Regulations. He is also the faculty for the various IIMs and B schools programs. Welcome, sir. Mr. Ranganathan will explain in detail about the provisions of the Act as well as the practical aspects in the first session of the webinar. Viewers can send their queries. We will take up the queries during the session as well as upon the completion also. I hope this session will enlighten the viewers and clarify about the doubts or the topics. With this, I would now request Mr. Ranganathan to please take up the session. Thank you, friends.
Yeah, good afternoon, friends. At the outset, let me acknowledge the contribution that the Institute has made by bringing in this kind of webinar series for all the members and the students as well. And I am also honored to be part of this intellectual journey that we have all undertaken. So with that small note, let me get into the topic of today's session, basically on the issue of securities and the various modes in which the securities can be issued. Friends, of late, if you have been seeing the capital market in the last maybe a couple of years or slightly more than that as well, one of the major things that the capital market has done is the IPO segment has picked up a lot in the last few years, and a lot of deals are in the pipeline during the current financial year, and for the next couple of years it is going to be the trend of the entire capital markets. So with that being in mind, I have devised this entire webinar for the duration into two things. One, I will be concentrating more on the IPO segment and then coming into the further issue of shares. Let me first, the reason for taking up IPO is we company secretaries have got a larger role to play in the fundraising activity of any company, be it a further issue for an unlisted entity or for a listed entity. And a company that is coming out with an IPO is has a far reaching consequence, and not only in terms of its journey that it is coming into the limelight, but also for the professionals like us, where the amount of contribution that we can make in the journey is something awesome and relishable forever. So with that note, let's come into and some of the tips or being a merchant banker, I also wanted to guide our friends or show a way as to how do we prepare ourselves before a company goes out for an IPO. Okay, first and foremost, friends, we all know about the Companies Act 2013, which is almost now 3 years in place, now 4 years to be precise, 4 years in place, and 2013 Act has very clearly devised certain sections which are exclusively carved out for the companies that are raising funds. Starts from section 23 and ends with section 42. Of course, you have section 62 as well for further issue and the preferential allotment. But section 23 is the basic thing which we all have to understand and start looking at, which very clearly demarcates that a company can come out with an IPO and a further issue of shares. It's very clearly laid down. Secondly, coming back, we all know that any kind of a company that is coming out with an IPO has to follow the SEBI ICDR regulations in toto. But we as company secretaries, we should also know where this power is coming from. Two very important points on section 24, friends, I would wish to highlight is that it is section 24 of the Companies Act that is giving powers to SEBI to go and administer the issue process. So please let's first read what is there in section 24, which gives the power to SEBI to administer it. That's first thing which I wanted to emphasize. Now it was there also in section 55A. Secondly, if you read the section, it talks about one more thing, that is a company which not only listed but also intends to list its shares. So two things, and in both the cases it was very well tested in the infamous story of Sahara. What we know about Sahara is most of us know on the private placement of securities, but there is also one more thing which was fought by Sahara on saying that that SEBI doesn't have jurisdiction because it is still an unlisted entity and SEBI does not have any jurisdiction over it. But if you look at very clearly about on section in section 24, it very clearly talks about those securities which are intended. So before you launch the IPO path, be very careful as to, are you really going into an IPO path or are you going to concentrate only on a few people? Then it becomes a private placement and you should concentrate on private placement. So it is we who guys have to advise the management right at the beginning of the IPO process when it is being conceptualized. So these are two things, very important things, which I just wanted to mention on section 24. It starts, you and I as company secretary should know that the Companies Act is giving powers to SEBI to administer it, and secondly and that's the reason why when it talks about intended to get its shares listed, and that's the reason we filed the DRHP with SEBI even before SEBI gives its final nod, and that's the reason, that's how the linkage needs to be established. This let us not forget. That's the first thing, first and foremost thing that I wanted to emphasize on this. Secondly, always we had a doubt as to when a company passes a resolution for a public issue, it's a very omnibus resolution that it passes, and whether it is in line with what is being contemplated is always being questioned. But friends, now section 62 has very clearly laid down that what is excluded in the section, which excludes public issue. So there is a clear-cut difference when you pass a special resolution for a company that's going to come out with an IPO under 62(1)(c) and a preferential allotment where you have to give plethora of details. So that's how the first, and in fact even the ICDR regulations very clearly talk about the distinction between a preferential offer and a public issue. Secondly, the IPO specified securities, ICDR. Once you come out of section 24, now you need to also to simultaneously read what is there in the ICDR regulations, which very clearly lays down the path for a company to go and fulfill the IPO process. In that manner, second thing what it is defined is what are specified securities. Now under the ICDR regulations, it is the equity shares and those shares that are convertible into equities are only the two kinds of securities which have been very clearly defined as the specified securities. In the process, I will also go through the debt issue regulations very briefly, or maybe simultaneously when you talk about a company that is coming out with a pure debt instrument, that is a non-convertible debentures in the form of an IPO, you have a different regulations to follow, and that is the issue of a debt issue regulations which needs to be followed, which carves out very clearly that even though a company is whose shares are not listed, it can do an IPO of non-convertible debentures. We will come to that later, but specified securities in fact is very clearly mentioned about only two things, equity and the convertible. That is the first thing which one has to talk about. Secondly, in IPO, most of us would be aware an IPO can be in the form of a primary issue or a secondary transaction which takes the nomenclature so called offer for sale, what we refer to in a M&A situation as an equity carve out. Okay. The two things which we have to say is, always we will have a question in our mind as professionals whether when IPO is always a primary issue, so that is the reason fundraising is one of the main activities, and so that is the reason we file all those documents with SEBI and also with register of companies. But friends, there is also a concept called offer for sale where the existing shareholders are given a leeway or an exit opportunity to exit. Now at least the regulators have thought over it way back in 1913 itself, saying that this kind of a provision should be there. So it is not something very new that has come in, but it is just a reiteration or a reminder to all of us, saying that even the Companies Act deals with what is an offer for sale. Section 28 very clearly talks about what is an offer for sale. So the point that I am trying to emphasize here is the enabling thing comes out from the Companies Act, but the administration goes to SEBI, and this principle was very clearly laid down in Sahara's 98-page order by Dr. Whole-time member Mr. Abraham in his Sahara's order. So friends, that highlights very clearly that the Companies Act enables a certain provisions or creates the securities, but the issue and the administration is left to SEBI and the SERA to take care of it. So two things, primary issue fundraising, second thing offer for sale, and off late offer for sale in the last a decade or so, if you see, there are a lot of private equity investors who come in much before ahead of the IPO when the company gets into an IPO stage. Now they have to be given an exit opportunity, and one of the ways in which the private equity investors get out is through the IPO route. And in the last couple of years, one more point I would like to mention here very clearly is, friends, 2013 Act very clearly defines who is a promoter. So does ICDR who is a promoter. It goes on to define what is promoter group as well, but there is a small difference between the 2013 Act and the promoter. The reason for me to take this way is, one is the Companies Act, second one is ICDR, and we as professionals and don't have the wrong notion that the entire document is prepared only by merchant bankers. Yes, we do prepare, but at the same time we as professionals, we should also be in a position to understand why we are drafting, why we are doing this, and all those contents. While we will see, I will also just take you through some of the 4-5 major things that what you and I have to be careful of when you draft an offer document. Okay, that is the first thing. Now when the private equity investors come and they invest in the company and they want an exit route, sometimes it happens that the percentage of shares that they are holding is much larger than the real promoters who have founded this company. So there is a question that arises here is whether the company, since they are holding far more for larger than the promoters, would they also be considered as promoters or a promoter group? Well, there is no one line answer for this, but the practice, it depends on case to case basis, and that is where I think the 2013 Companies Act also has brought in the concept of control, and section 2 subsection 27 very clearly talks about what is control, and it is nothing but a replica of what is there, how it has been defined in a takeover code as well. But this is a very clear thing that a control definition should also be read thoroughly before you actually start drafting the offer document, and that is the reason I just wanted to emphasize as the point of control. So if you look at certain shareholding pattern of certain companies, a very few companies countable where the promoters might be holding lesser than the other private equity guys. So this question will definitely arise. So friends, if you are have the IPO path, if you are in the process of doing an IPO, and if private equity investors are, it's better to get a clarity at this juncture before you actually launch the issue. So that's one word of caution that I just wanted to mention to our friends who are all about to do an IPO. So that is then secondly, before you get into an IPO path, I'm just going on the very broad concepts. One is always check on the general conditions, whether you are satisfying the general conditions, that's the issuer is satisfying the general conditions as laid down in regulation 4 of the ICDR. And two very important things, friends, is that one is the promoter or a promoter group or anybody associated with that should not have been debarred by SEBI from accessing the capital markets. Okay, that's one thing. And second thing is they should not have been also under the willful defaulters list. Okay, a strange case arises in some circumstances, especially when in case of family owned businesses, where some brothers who are all been as promoters initially. Now some cases when they do not have any kind of a contractual relation with each other, and they are not even on talking terms. Now today, how do you classify them as a promoter, and how do you bring in there, and he is not ready to, that is where the challenge comes, friends, for us. How do we go and get their documents signed, and how do we mention about him as a promoter? So this is one practical difficulty, which the other difficulty, one is on the control and the private equity, second thing is on the promoters who have been named initially, and how you will have to show them if the relationship has been cut off, and how do we want to show them is the second thing which
the relationship of company secretary also become a tedious task to manage the relationship between the promoters when they are not in the talking terms, and
absolutely,
and it's a confidentiality of terms become a challenging task for the professional that time.
Absolutely. Yes. One more thing just to add to what Praveen says is one of the major diligence thing which we face is today when you mention the particulars of the directors in the offer document, you need to give the entire plethora of his details about his qualification and his experience. Now as a diligence measure, we should not just depend on what the director says, but we need to go and find out, and in fact the SEBI, the regulator, is insisting for the adequate backups for that. For example, how do you justify that XYZ is a graduate? You would have completed way back in 1945, but how do you go and justify? We should have a copy of it, else we should leave his qualifications blank. So be prepared. As I said, the relationship counts very much. It's only we guys who will have to go run around and get this information. So that's the reason I'm trying to point out right at the beginning that before you venture, please let us sort out all these things, and then maybe get into the launching pad. Okay, so apart from the eligibility conditions, then you have the eligibility. From the general conditions, we shift to the eligibility conditions, which are very clearly laid down under regulation 26(1) and 26(2) of ICDR. Now the administration process has started, and that's the reason we have to look into what ICDR basically talks about. So regulation 26 gives 3 criteria, one on the asset size, on the profitability, and on the net worth criteria. Just see whether we satisfied all these 3 conditions, and all these 3 conditions, and then we will be able to launch, because the entire issue depends on whether we fall under the 26(1) or under 26(2), because most of us might be knowing there are 3 categories of investors in an IPO, one on the qualified institutional buyers, second is on the non-institutional investors, and the third is the retail individuals, retail investors rather. So the entire breakup of things in 26(1), its QIB is 50%, the institutional investors is 15, and the retail is 35, but in 26(2) it is at least 75% of the issue size has to be subscribed by the qualified institutional buyers, else the entire issue stands withdrawn. So there is no question of allocating from one place to other. So this is one thing which, as in terms of eligibility condition, that we should be taking care of right at the beginning. Couple of other things, when we talk about the Companies Act and the ICDR, we should not also forget what is SCRA doing in between, which is an exclusive act which has been dedicated for the Securities Act. Okay, so in that case, the rules, securities contract regulation rules of especially 19(2)(b) is one thing which we all have to be aware of, which talks about the minimum public shareholding limit. Presently there are 2 limits of 25% and 10% if the issue post issue size, post issue paid up capital is more than 4,000 crores, that it is enough that issuer comes out with a 10% offer to the public, but within a period of 4 years he has to bring it back to the 25% limit. So 25, so the minimum public shareholding limit is envisaged under rule 19(2)(b) of the SCRA rules. That's third one. Rather the fourth one, general conditions, eligibility, SCRA minimum public shareholding, and the fourth one, let us not forget, ultimately all the equity shares are going to be listed on the exchanges. So they have a criteria as to what minimum criteria what a company should satisfy. 2 criteria, one is on the paid up capital, the second one is on the market capitalization. First one is post issue paid up capital should be more than 10 crores, and the market capitalization should be more than 25 crores. So 4 things which we need to satisfy ourselves. Friend, general conditions, I will reiterate these points because that is where we as company secretaries have got a lot of role to play. General conditions, eligibility conditions under 26(1) and 2, the SCRA 19(2)(b) rule of SCRA, and the basic conditions of the stock exchanges before we go and list our shares. Okay, in terms of, while you go through the path of IPO, you need to start preparing once the diligence starts. What is the role that you and I have to play? You know, it has various sections. ICDR Schedule 8 talks about what are the different things that have to come into the offer document, but what is the role that you and I have to play, especially being CS professionals. First and foremost thing, friends, I would rate, at least from our side, is that the capital structure and the capital built up of the company. It looks a simple job, friends, but that's one of the most time consuming and the most difficult task as well, because tell your clients, if you are on the advisory side or if you are the issuer, be very careful that ensure that the paid up capital is 10 crores much before you launch the issue, though it talks about post issue, because in many cases it so happens that ultimately you find out that the paid up capital is not enough. So you need to do a lot of other restructuring, the financial restructuring before, so please avoid that. So the capital structure and the capital built up. The reason for talking about the capital built up is right from the time that we start this process, please go back to the incorporation days and take out all the Form 2s of the 56 Act and the PAS 3 which you would have filed recently in the last 4 years, and keep it ready along with the register of members, is what I just wanted to very clearly mention, because everything is going to be replicated in the offer document and we can't take a chance in that because it is also publicly available. So please ensure that everything is in place. So capital structure is one of the major things that you and I have to be careful about. Second thing comes about the approvals and licenses. This might be very peculiar to a particular type of a company or a particular type of an organization, but yes, approvals and licenses are something which are very, very crucial. For example, if a company has got a lot of overseas subsidiaries and if it has to take licenses and whether under their jurisdictions, whether everything is in place and the due diligence is being done to that extent. Ultimately, what are we trying to do with this? Whether we are informing the investors about whatever things we have and whether with proper approvals and license, whether we are carrying on the business is what is ultimately. So as a CS, we should help in our advisors to have the adequate backups. So approvals and licenses is another major criteria, especially if you are a regulated entity and if you have plethora of subsidiaries and especially in overseas. For example, if you have a lot of intellectual property rights, one should also go and check whether still the validity of those intellectual property rights are there or not. So this is also one of the major things that you and I have to take care of, friends. And the third thing comes litigations. Okay, third thing is on the litigation front. Now every company will have a lot of litigations and it becomes very difficult to capture because today we don't have a pan-India presence to capture everything, and if it is a group companies having a wholly owned subsidiary abroad, how do you take over, how do you factor those litigations into the offer document, and sometimes it will be only in foreign language. So do you need to actually translate into English and put in, is some of the major things is that we need to be very careful about how do we go about it, because this becomes a huge task. So litigations, and in fact
as far as this translation is concerned, we have seen that most of the times the advocates and the advisors requires the litigation documents into English only. Rather we prefer, sometime we got the documentation and the matter which has been filed with the before various courts into regional areas, they are into regional language, sometime into South, sometime into Rajasthan, it's into Hindi and all that. But most of the time when we are going to the regulatories, it is preferred to be in English only. So translation need to be presented. That is the biggest challenge I think comes to the people.
Absolutely. It's not only in Indian languages, assuming you have foreign subsidiaries.
Yeah, that is
how do we? That is a challenging one.
Yes.
So materiality concept is one thing which you and I have to be very careful about. Though the ICDR mentioned about how do you classify the materiality, I think normally it is based on your consolidated turnover or the profits, depending on what you want to take on the materiality threshold. But apart from stating the materiality threshold, it also talks about the other litigations have to be summed up and given a proper figure about what is the number of cases that have been outstanding, and that also needs to be mentioned very clearly in the offer document. Then comes the risk factors. Though risk factors is mostly on the business side, but there are certain other things. For example, in case you don't get the approval or approval is going to be a challenge, how do you factor it? Some of the things we might be directly handling it. So how do you convince and how do you draft that particular language so that everybody is aware of what is being conveyed through the offer document is one of the things that So the risk factors, friends, first comes risk factors is a criminal liability, or the if there is any criminal case against the promoters is what is the first thing that comes in the risk factors. So when you do, though we will have a lot of advisors and the legal counsels to help us in doing all those things, but it's better that we prepare ourselves as to what kind of litigations, what kind of the risk factors that will go. The litigations also, some of the litigations might turn out into be a risk factor also.
I have one query, Ranganathan. As regards if you are talking about the litigations or the company management or the directors or the CEO, most of the time we have seen that the people or the vendors are filing the litigations against the company and they are making generally the party to the managing director or the CEO of the company. Sometime it is on the position, sometime on the individual. So whether both have to be taken considered at the time of giving the information on the risk factor?
No, it depends on, first is promoter, you need to very clearly find out, you need to go into detail and find out to what extent it's been on the promoter and the company.
Yes.
But in case of an individual or a KMP, or not even a KMP, but who is occupying a senior management position, or a normal guy who has been authorized to represent in a day to day, whereby what do you call by principle of estoppel, that he is construed to be a guy who is in charge of the affairs of the company, then you can always take a call as to what is the extent of necessity that is required to be shown in the. So ultimately it depends on the nature of the litigation that is involved. Second thing, on the money that is going to be involved in this, and in case anything, whether it is going to result in a future liability.
Anyway, it will be there into the company's litigation.
Companies, of course, that's what I said. You need to segregate into both. One, the materiality, the other things will fall under the. Why I am saying this is very crucial, friends, is in some cases I think some of the issuers would have witnessed this, in some of the cases where the issue would have happened, the issue would have opened rather, and there is a guy who comes and says that my particular litigation has not been captured in your or HP or the offer document. So I need to be included, and please advise the company to stop the issue. Now how do we tackle, and that's the reason I am very clearly saying that it's better that the issue might be delayed by a few days or a few weeks, but let us be very careful about what are the documents that are required. Ultimately you and I have to go run around this and do it, and getting the backup papers from the issuer, or that's why when I am looking at from an issuer point of view, we should be very very what do you call cautious in obtaining all these things right from. So please set alarm bells for each of the departments that are totally involved in this offer document or in the IPO process. One such department which alarm bells have to be continuously ringing is the litigations or the legal team. So please we need to ensure that this is done. And then comes the financial statements. Though we may or may not be directly linked or related to the financial statements, yes, there are 5 years figures that needs to be stated, and whether let us ensure that all the financial statements, all the AGMs have been properly held, and all the forms and the balance sheets have been filed with ROCs in time, because all these things should not come and let us down. These are all very simple things. If we take care of it at the first stage itself, I think these are all very simple things to go through, with the issue can sail through very easily, and not only that, we will be facilitating the entire issue process very smoothly, and that's the reason I just wanted to emphasize on some couple of points. Of course, we have the material contracts, which comes as a part of your entire thing in the offer document. If you look at the last page, the entire material documents that comes into being, and so that you take care of it. And the articles of association, normally we don't pay much attention to articles of association. So please friends, there are n number of places where the act subtly or very clearly talks about a provision in the articles of association, especially if you have a shareholders agreement before the company has come out with before the company is coming out with an IPO, see to it that all the provisions have been very clearly mentioned in the articles, though all the restrictive provision will stand cancelled when the company becomes a listed entity.
As regard these articles is concerned, I had seen when there is private equity investment is there, and the investors have some priority rights over the articles, but when you are going to the public, these rights got abolished and the public become the ultimate owner. So that time we had seen that the changes need to incorporate into the article so that it suits to the requirement of the SEBI. Otherwise, at the time or after the filing of the DRHP, SEBI will say and come and tell you to change the entire articles, and then it will take too much of time to call the AGM and to amend the articles. So better to have the articles amended way as acceptable to the SEBI.
So this is one of the precautions, because it entirely falls under our domain, and we should not falter in this. Okay. Second thing, which going forward, one of the things, now having talked about the risk factors and other major things that are coming in the offer document, the corporate governance requirements which also have to be taken up before the company becomes listed, or before you actually file the DRHP with that is one of the requirement of SEBI, saying that you please comply with all the corporate governance requirements just before filing the DRHP. So in terms of, not in terms of what the filing of certain things which is applicable post listing, but in constitution of different committees, that's one of the things. First is board composition. How are you going to, whether it's whether the chairman is an executive or a non-executive, so whether the board composition is in line with the LODR requirements.
Yes.
Second thing is on the various the statutory committees, starting from the audit committees, the shareholders investor grievances committee, of course CSR committee. CSR committee though directly not mentioned in LODR, but yes, we need to be careful about what is being the constitution of committees as far as the corporate governance requirements are, and I think SEBI and stock exchanges were very clear in administering the fulfillment of all these regulations. Then comes certain agreements that are required to be executed along with the IPO process. One is the issue agreement between the company and the merchant bankers, the issue agreement that needs to be executed, and if it is an offer for sale, even this issue agreement is also is to be executed along with the selling shareholders. So in an offer for sale they become selling shareholders and you need to execute it. Then there is this escrow mechanism, escrow agreement, where the funds that have been raised through the public issue needs to be deposited initially in an escrow account, which gets transferred to the public issue account of the company post the approval, post the basis of allotment, and then it actually gets transferred to the company's account only after the trading approval is given by the exchange.
As regards this offer agreement, what I understand, if it is an offer for sale by the existing shareholders, the liabilities and responsibilities of the shareholders or the selling shareholders with the company goes simultaneously. So company has to take care about its own responsibilities and all rests and warranties, as well as the shareholders and promoters has to take care of their own responsibilities. So both the parties are simultaneously liable to the BRLMs.
Absolutely, and in fact offer for sale, it's a purely a secondary transaction, as I mentioned initially, between the selling shareholders and the prospective investing public. So ultimately I am only a shareholder of this company, and I will not be in a position to give you indemnify the activities of the company, but to the major extent I can only testify my title to the shares that are being sold, but as Praveen rightly mentioned, you should also be in a position, the company should also facilitate in giving all those undertakings. Finally, in an offer for sale too, lot of undertakings have to be given by the selling shareholders. So how do we take care of it is one of the major things that so that is issue agreement, escrow agreement in terms of then there is a syndicate agreement, which the issuer enters into with the syndicate members. Syndicate members are nothing but a broker in a primary issue. What we call in a secondary market is in a primary issue a syndicate member, where the entire bids are being or being given to him for bidding. Okay, and then if there is an underwriting, yes, you need to enter into some underwriting agreements as well. These are some of the major agreements that are really needs to be entered, and we need to be careful about. Then there is a concept of lock-in, once promoters lock-in and promoters contribution. These are two major things, friends, especially more than the locking, it's a promoter contribution. That is please let's revisit those provisions under the ICDR as to what do you mean by a promoter contribution, what kind of shares are eligible to be considered for the promoters contribution, because it talks about 20% at least promoters have to contribute in the issue, which has to be locked in for a period of 3 years. So the promoters contribution, there is a great calculation as to what is eligible shares for the promoters contribution, what is ineligible. For example, one of the things is, if bonus shares have been issued out of revaluation reserves, then those shares will not be counted for the purpose of promoters contribution. So who is going to guide the management? Don't think that only the merchant banker, though again I reiterate, I am a merchant banker, though we all guide the clients, but in fact it's for, because if I am on the other side, I need to be cautious of this fact as well. So it is better that we ourselves prepare for this. So we need to be very careful about. So if you have any plans of doing it, please advise the management not to do a bonus issue out of revaluation reserves, is what I am trying to tell you, because it won't be counted for the purpose of the promoters contribution. And lock-in provisions are very simple. The promoters, whoever is holding the promoters, it will be locked in for a period of 20% will be locked in for a period of 3 years. Anything more than that will be locked in for a period of 1 year.
1 year.
And any pre-holding prior to the IPO will be locked in for a period of a year. So if there are any other existing shareholders, if they don't participate in the issue process, all those shares will be held and locked in for a period of 1 year. So that is one more thing which I just wanted to mention it. A great thing that has come in the Companies Act 2013, which SEBI has finally formally approved and got included by including a chapter in ICDR as well, is the exit offer mechanism to the dissenting shareholders. So what does this mean, and what is this? Is a new concept which we had not seen. Friends, just if we can recollect what was there in section 61 of 1956 Act, it talks about whenever there is a change in the variation of contracts in the prospectus that the company has issued at the time of IPO, then by merely passing a resolution, 61 was silent on what type of resolution to be passed. So people were varying, the companies were varying the objects clause from what was stated in the prospectus. So first thing is, let us define the objects of the issue very clearly as to what it is, because that is going to be, and if the issue size is till June 30th, if the issue size was more than 500 crores, you need to have appointed a monitoring agency. But if the issue size is more than 100 crores, now you need to have a monitoring agencies. Monitoring agencies are nothing but the banks and financial institutions who will be monitoring the use of proceeds that have been garnered through the IPO process. So it comes as a part of your quarterly results as well. So let us define the objects of the issue very clearly so that we can avoid. So if a company varies its objects from what it was stated in the prospectus or in the prospectus at the time of an IPO, then an exit offer needs to be provided to the dissenting shareholders. The mechanism is very simple. Section 27 very clearly talks about what kind of things have to be done. The only thing the SEBI ICDR by way of a separate chapter as talking about the process that needs to be followed, and this is one thing is on the special resolution. Second thing is, even when you vary the terms of the contract, it cannot be used for investment in listed entity shares. That is the second option, and there is a pricing formula as to at what price, because the company would have already been listed. So what is the price at which you need to give the dissenting shareholders? The price is also mentioned in the ICDR very clearly about. So the reason for friends pointing out all these things at this juncture is exit offer mechanism we may not be aware of, and until now after this has been notified and SEBI has included this in a separate chapter, none of the companies have done this. Hopefully we don't come across such kind of issues. So exit offer is something which you guys we all have to be aware of. Please read those section 27 read with ICDR chapter 6A I believe. So please read it very carefully before whenever the management tells you to change the objects from what it was stated in the variation. But don't get confused with the safety net mechanism which is envisaged under regulation 44 of the ICDR. This is different, and exit offer. Now exit offer has to be given by the promoters. Also ensure when the exit offer is being given, when the promoter takes back certain shares from the dissenting shareholders, it should not cross the maximum non-permissible public shareholding as envisaged under the SARA and the Takeover Code. That needs to be fulfilled. A safety net mechanism is something which you are providing to the retail investors, up to who are holding up to 1,000 shares for a period of 6 months post the listing of the shares. If the price has come down, then they have a mechanism to fall back on the promoters to go back and surrender their shares or give back their shares rather at a particular, and the promoters are obligated to purchase at the issue price. There is a mechanism again the SEBI has laid down, though most of the companies are really not these days. Very few companies come out with a safety net mechanism. So please ensure that that is also in place. And now today the entire listing process, previously it took a lot of months to get the shares listed, but now once the issue commences, it all has to be completed within a period of T plus 6 days, that is 6 working days from the date of closure of the issue. The entire process has to be completed. Now this is going to be reduced further down to T+4 in the days to
Coming
come.
days.
In the days to come, maybe within maybe the beginning of next year, we'll see that. So, though all the regulatory mechanisms have facilitated in doing this in a very smooth process, and here the best thing is how do we do it. The registrars plays a very great role in this the entire process, the post the closure of the issue, and of course, so T+6 is the current situation which we are going to T+4. So let's be careful about whatever. So if you are a registrar, or maybe even on from the issuer side, let us ensure everything is an upfront. It looks very simple job, friends, but going back and when you execute it, you will find even 32 hours a day will not be sufficient for us to complete an IPO process. So let's be prepared ourselves. And one more thing on the IPO front which I wanted to very clearly mention is, I don't know how many of us would be aware of this, but there is this general circular of SEBI which talks about rejection of offer documents. This is another thing which I think right from at the beginning we need to be careful about rejection of offer documents, and please let's go and see what was there in the general circular of SEBI of October 15, 2012. It talks about different situations. So the reason for mentioning this is ultimately, if you see, one of the thing is whether the capital structure involves multiple round of things, whether how that is the reason I emphasized at the beginning that the capital built up and the capital structure is very crucial for us. One of the other things, if you see, even the Companies Act 2013 has captured in terms of what you want. One of the things that we have to mention in the offer document is the source of promoter contribution. The point that I mentioned about the promoter contribution, now you also have to mention about the source of promoter contribution. So it all depends on how old is your company, whether you have records. So at least if you know that your company is just a 5 to 10 year old company, please go back and just try to find out and take the backup of the promoter's contribution.
The company is through inheritance and it's having long history of the running, so whether they need to come out with the source of the money which their promoters or the ancestral would have come out.
Basically, to whatever extent. For example, if assuming that Tata Steel, which was incorporated in 1907, wants to come out with an FPO, whether you will be able to find out, the answer is no.
No.
So to whatever extent possible, but I can't say a company that is only a 20-year-old or a 30-year-old to say that I will not be in a position to do the promoter's contribution. So if such a company is contemplating to come out with a public issue at this present juncture, let's go back and see to whatever extent possible. It should be a reasonable thing. I would believe that entire thing needs to be shown, but in cases what you pointed out where it may not be able to really establish, maybe a view can be taken on a case to case basis, but this is one of the major thing which has come in the Companies Act itself. So when you read section 26 along with the rules there too, it talks about the source of the promoter contribution as well.
So idea is basically to have to the best extent you can dig out the sources of the funding which the promoters are there, just to avoid any other source of or any unknown or illegal sources of money which people can use for the IPO purposes. That is the basic idea of the regulators to move out from the system.
Okay. Second is objects of the issue. Friends, I will reiterate objects of the issue. If it is very vague, then the regulator is going to reject your offer document very clearly. So define your objects of the issue very clearly, especially there have been cases where prior to the public issue, lot of companies have done lot of transactions through what you call as an intra-corporate deposits, and finally the funds that have been mobilized have been routed back to the promoter's personal account. So the ICD transactions is one example of such a thing. And in fact, if you are setting up a plant, please ensure that all the orders and other things, the bills and the invoices that you are raising is a genuine one, and please keep don't hesitate to take. We maintain only the soft copies of these days, right? But in addition to that, let's also maintain a hard copy of all these things, though it looks very simple, but let's maintain. And thirdly, the business model. Many a time we also find the regulators are not comfortable with the business model. If we professionals and the regulators are not comfortable with the business model in which with the issue is going to be issuer is going to come out with the issue, just imagine the plight of the retail individuals, and that's the reason even the business model has to be kept very clearly. And if there has been a change in the accounting policy and spurt in the business in the last few years, that is also one of the reason, and SEBI has clearly given some more criteria about. So please go and read the SEBI rejection of offer document circular dated October 15, 2012. And so as far as the public issue of the equity shares are concerned, this is what broadly I just wanted to cover at this juncture. And from this you want to take I can take questions on the IPO at this juncture,
You can have the question at the right moment also, it's there, but not directly
more on the rights issue, right?
More on the rights issue or the OCDRs and all that.
OCDRs. So let's come back from the IPO, assuming a company that has come out with an IPO now wants to do a further issue. Now let me split this entire rights issue and the further issue of shares into two buckets. One is on the unlisted space and the other one is on the listed space, as to how do we do it. So let's go with one by one as to, let's first take the rights issue.
Okay. Let
me take the rights issue as the first one, because it's easier to deal with the rights issue than a private placement these days.
Right.
Okay. Okay. As far as a rights issue is concerned, irrespective of whether you are a listed or an unlisted entity, section 62 subsection 1 gets attracted very clearly. So you need to have a resolution passed, the board resolution passed very clearly. One wonders, though one wonders as to why a lot of questions are being asked as to, in case of a rights issue, why we need not have to go to the shareholders and take their approval. But the section in the earlier 56 Act, section 56 subsection 5 was very clear, which is being replicated in 62 subsection 3 as to very clearly as to why a rights issue doesn't require to go to the shareholder. So that is the first thing that you and I have to be aware of, that with the board resolution I can do a rights issue. That's the first thing. Second thing, whether it's a listed or an unlisted. Second thing is, on the only to the equity shareholders a rights issue can be offered. Okay. In terms of some exceptions between the listed entity and the unlisted entity, let me just tell one of the exceptions is that the ESOPs that have been granted to the employees, that will also, once it is being exercised, once it is being exercised, he also becomes a shareholder and he will also be allotted the shares. So you need to make a reservation for such kind of a thing. It's what is contemplated in the listed entity space and which is not given in the unlisted space. So that is one thing, reservation for anything that is convertible into equity shares at a later date, if it is outstanding as on that particular date when you come out to the rights issue, that a reservation for that needs to be made. So which is not there in the unlisted space. Second thing, in the unlisted space, if you see, a consideration can come, in both the cases the consideration can come only in cash. Third one, is there a price restriction? When I am talking about this, let me touch on the reservation also. A very peculiar thing, if you can see in the ICDR regulation 55A, this is one thing, a thing to ponder over, friends. It very clearly lays down that when a company comes out with a rights issue, it can reserve certain number of shares to the employees not exceeding 2 lakh shares worth of shares to a particular employee. Now it can reserve in a rights issue. Normally we feel that a board resolution, with the board resolution it's enough that a company comes out with a rights issue, but if you are going to have a reservation for such employees, what is the question that we need to ask ourselves is that, since a new shareholder is also coming into place, not through renunciation but through some other method, whether a special resolution is required to be passed, even in case of it's a food for thought, a point to ponder over, because on one hand you will say that 62 talks about anything to a new guy you need to take a special resolution, but SEBI allows you to do this. So we need to ponder over this. In my view, again, it's better that on a conservative basis, it's better we take a shareholders approval in front and then get into this act. So the reason for pointing out that this is purely lies in our domain. So there is a reservation tomorrow when your management says I want to reserve something for my guys, for my employees in a rights issue, let us also be prepared for this. Then thirdly, we also know in a rights issue normally the pricing is not a major issue in case of a rights issue, because if it is a listed entity, we all know that normally it will be priced below the current market price, and that is because we intend that we feel that the entire issue will be subscribed to that extent. If it is lesser than that, otherwise I have an option to go to the market. But friends, there were cases in listed space where if you look at takeover code exemptions, it talks about if the promoter has very clearly given an undertaking in the letter of offer saying that he is willing to take the unsubscribed portion in the rights issue, then even if it crosses the takeover trigger limits, he used to get an exemption from the obligations of the takeover code. But those days have gone with after the 2011 takeover code has come in place, and please friends, before you fix a rights issue price, let us also go and read what is there in regulation 10, especially when it talks about regulation 10(4)(b), when it talks about the pricing formula that is required to be, the price cannot exceed an X rights price. The calculation has been very clearly given in the regulation 10(4)(b). So please, if you are in a listed space, of course again advisors are there to do it, but never mind, it is also in our domain is what, and that is the reason I am emphasizing on this point, that is in our domain, so we need to take care of that aspect as well. So in case of the unlisted space, there is no restriction on the price. Basically, you do a normal valuation and get it done, and of course 62(1)(c) talks only about a valuation for a preferential allotment and not in case of a rights issue, but yes, never mind. Yeah.
In case of right issue, is there any requirement to have the valuation from the merchant banker or class 1 or something from a valuation report from a chartered accountant?
As of in which case, listed or unlisted?
Unlisted. I am talking
unlisted, because listed it does not require anything. Unlisted as of now it is not required. Unlisted it is not required, but
valuation report is not required.
Not required, but how do you even for an unlisted space, how do you even justify? So it is normally whenever you are doing a valuation of a share, it is always accompanied by a valuation report. So it is better to have it, is what.
But there is no compulsion to have it from merchant banker.
There is no compulsion to. You can have it from a practicing chartered accountant as well.
Okay.
Okay. Now. One more thing, the intention of the promoters to participate should be mentioned in both the, whether it is an unlisted or a listed space. Now a peculiar situation which I think suddenly we all have arose to this situation, and seeing the notice of dispatch of letter of offer, at least 3 days should be given to before the rights issue opens. Okay. Now just imagine a case where there is a what do you call, a holding company and a wholly owned subsidiary company which intends to do a rights issue, and the holding company wants to subscribe. Now we all know that it can be done in maybe in a few hours time.
Yes.
So how do you tackle this is one thing. Should I wait for a period of 3 days and do it, and what is the amount of so it is again a food for thought. Is this 3 days? There is no exception that has been carved out in this case, but yes, we need to be wary of this fact. Record date is essential in the listed, in case of a listed entity, and of course in case of an unlisted entity it is better to have a record date, because a record date is nothing but to determine the eligibility of the people who are eligible to subscribe to the rights issue.
I have one relevant question here from one of the viewers. In case of a private limited company, can right issue be closed within 15 days period? 3.
It can be closed, yes, in case of a private limited company. The one thing which I just really wanted to point out at this juncture is the 1956 Act very clearly carved out an exemption for a private limited company fully. None of the provisions of the rights issue was applicable, but 62 there is only one catch, and it talks about in case of the offer period, can it be reduced within less than 15 days, yet it can be on obtaining 90% consent of the existing shareholders, is what is there in private limited. I do not know why even a private limited should be be restricted to these kind of things, but yes, it is possible, friend.
Again, there is one question which we recently discussed about the preferential allotment and valuation report. The question is from the viewer, in case of a preferential allotment, whether valuation report can be taken from any chartered accountant who is not a registered valuer.
As of now, it talks about only a what do you call a registered valuer, because
Yes.
now it has been notified. Now it has been notified.
Okay.
Okay, let me finish rights
Yeah,
issue,
please.
so that the preferential, when we come to that, we can take on that. So one of the major thing, friends, especially listed space, I just wanted to caution that once you announce the record date, you cannot withdraw the issue. It has to go through. If you withdraw, then you cannot access the capital market for the next 1 year. So that is, and you cannot list any kind of convertible securities with the exchange. So that is one thing which, friends, you need to be careful about. Even ASBA has been made compulsory for rights issue, so in that way it is also, but the issue period remains the same for 15 to 30 days in both the cases, whether it is listed or an unlisted. The only difference from an IPO and a rights issue point of is in case of an utilization of funds. In case of a rights issue, the company can start utilizing funds immediately after the base of allotment is finalized, but in case of an IPO, unless the trading approval is obtained, you can't use the money. So these are the major differences, or I just wanted to cover in terms of listed and then unlisted space, so that wherever we are working or whoever we are advising will be enough. Anything on rights issue, brother?
Nothing on rights issues on IPO and others.
IPO and others.
Yeah.
So IPO, is there anything?
IPO is there. There's one question. Can there be some portion be reserved in IPO for mutual fund?
Oh, okay.
I think it
is not the reservation that primarily takes place in the mutual funds, but yes, it is as a part of anchor investors. They come as a QAB, and as a part of QAB, 5% should be allocated reserved for. So the reservation comes in the QAB bucket, not as a separate reservation that we are talking about. The only thing which SEBI has enabled is, in case of a promoter contribution, if it is falling short of 20%, less than 20%, the remaining balance can be plugged in by alternative investment funds. That's the only category 1. Now even category 2 has been included as a part of it. That's the only thing which has come. Mutual funds will fall under the QAB bucket, and yes, you can have reservation within the QAB bucket.
There's one more question related
to this reservation is different from the reservations that you make for an employee or for a
that is different.
Yes,
that is 5%
yes,
for employees.
That's fine.
There's one more question relating to IPO. In case of an IPO, though through offer for sale, whether objects of the issue need to be mentioned in the prospectus, as there is no inflow of money. So I think to the market it's not required, with exempted.
No. Any kind of an issue, because ultimately you are listing the shares of the reason for why do you want to go through the entire process of DRHP, RHP and the prospectus, because the objects need to be mentioned, but in an offer for sale there are only two main objects that will come. Is one, to get the shares listed on the exchange. Second thing, to give an exit opportunity. Yes, objects have to be mentioned. Only thing, there is no concept of monitoring or
business development.
It doesn't directly acquisition or whatever it may be. There is no fund which has been coming into the company.
Yes,
it is there. Yeah. So in case of a preferential allotment or private placement, whatever, though the 2013 Act has clearly earmarked private placement and preferential allotment in two different sections, though section 67 of the 56 Act very clearly talked about any offer of securities to more than 49% will be deemed to be a public issue. There were not much of a detailed things that were mentioned in the 56 Act, and thanks to the infamous story which happened, which we all know, and that paved way for to plug in the certain loopholes that were not basically taken care of at the initial juncture itself, and that's the reason section 42 has come in place. It very clearly talks about not to be issued to more than 200 people, 200%. Understand, friends, it is not the prospective allottees that you have to count, it is the offering that is made to the people that will count rather than the prospective allottees. So let's not be under the impression that we offer it to some 1,000 people and only some 50 guys finally subscribe to that. So it is not that, even the number of the offer that is being made counts, and that's the reason when it is being offered, there is a number that carries with the private placement letter of offer. So let us be careful, and that is why you have so called what you need to identify the, essentially the reason for doing it is you need to identify who is going to invest in this company, and that is the reason both in listed space and as well as in the unlisted space it talks about the identification of the proposed allottees. In fact, if you look at chapter 7 of the ICDR, which talks about the listed space, it also goes to the extent of finding out who is the ultimate beneficial owner if he is an individual. That needs to be stated very clearly in case of a preferential allotment when you do for a listed entity. Okay.
There is one question relating to right issue. Can optionally convertible debentures be issued through right issue?
Maybe, why not, because ultimately it is going to be converted at some point in time or other. Today, how will you reject that kind of a thing, because because though you may not know whether it is going to be fully convertible or not, but today there is every possibility that entire thing may be converted into equity shares. So in my view, it is all my views, right. So so yes. So coming back into the preferential and the private placement of thing. Now one is, as I said, it can't be more than to 200 people is the first thing that you need to mention, you need to be aware of, sorry. And then secondly, 62(1)(c) enabling resolution by way of a special resolution is required, and the only exception that ICDR has carved out is if you are allotting by virtue of a scheme of merger through the NCLT, then the preferential allotment rules will not be applicable. That is one of the, especially the pricing and other factors will not be applicable. And for a unlisted space, you need to have a valuation done of the shares that are going to be issued on a preferential basis, but in case of a listed entity there is a pricing formula. Section 76 very clearly talks about regulation 76, sorry, talks about what is a pricing formula, and it also talks about a relevant date for this. So one of the things which regulators also feeling, especially when in case of a preferential allotment of shares, the explanatory statement which very clearly needs to state the identification of the identification of the prospective allottees is not mentioned very clearly. So in all probability, friends, though you may pass a special resolution and file it to the exchange for listing, in all probability exchanges are going to reject if you do not take care of this aspect at the beginning itself. And again, the relevant date, though it is very clearly, while calculating the relevant date, it is advisable that you recheck it, and maybe offline you can also consult the exchanges as to whether you have calculated correctly, because normally what happens is when it falls on a holiday, you should normally we take it on the previous day. So but the exchanges, if you really go and see if it is falling on a, say on a Saturday or a Sunday, normally we take a Friday, but ideally it should be taken as the Thursday. So friends, it's a word of caution. So pricing in case of a preferential issue, let's not take it very lightly, please, let's have this. And so the second thing is failure to exercise warrants. Now in case of preferential allotment, the companies can also issue warrants to the promoters, and if they had failed to exercise the warrants previously that have been issued to them, and they are not eligible to participate in the preferential offer. This is not there in case of a unlisted space.
Yes.
Okay. Coming into the unlisted space, a preferential offer needs to be authorized by the articles of association. Again, it's totally under our domain. There is an exception, that's, it's not an exception if you read very clearly. The articles of association is authorization by the articles is for the unlisted space and not directly for the listed entity. That's one thing which, and in case of a listed entity, those who have sold those shares in the last 6 months will not be eligible to participate in the preferential offer. Now very recently, sometime recently in one of the informal what SEBI has given, there was a transfer of gift of shares from husband to wife, and a preferential allotment was supposed to be made to these people, and SEBI very clearly said that even a gift between the promoters tantamount to a sale under the Sale of Goods Act, and hence they are not eligible to be. So there are plethora of things. We normally think it's a small thing when gift is in the normal course, what we think as a gift, and within gift, and that too within the promoter, should be outside the ambit of anything, but it's not the case. So if you are in a listed space, let's be doubly cautious of what we are saying, what we are doing. And the resolution that you pass in case of a preferential for a listed entity is valid only for 15 days. Within 15 days you need to make the allotment, except in case when you don't get the statutory approvals. Okay, but in case of a unlisted space, preferential offer can be completed within 12 months. Again, a convertible security in case of a preferential offer under a listed space cannot exceed 18 months, whereas in case of an unlisted there is no such specific requirement. And thanks to whatever episode has happened, but section 42 you should read section 62, which talks about the preferential offer, along with section 42, which very clearly talks about opening of a separate bank account for each issue. This is one of the issues which being an unlisted space we encounter very frequently, is that if you are doing lot of issues in a particular year, should I open a separate bank account for, because it is administratively it is becoming very difficult to open and then to close. So
there is one question relating to the conversion which we discussed just now. Can conversion of preference shares into equity shares issued for 5 years, can we further extend it?
Why not? By passing, it is basically, I would feel it is more of a variation in the shareholders' rights rather than in a preferential offer. So you can always do it under section 48.
Okay.
Yes. Only thing, if you have any other preference shares or any other, it should not affect the rights of any other shares, and if it is there, you need to take their 75% of their consent as well. So and this reply to this is, please refer to section 48. Okay. So coming back, so you need to have a separate bank account. This is one issue which normally a closely held company, whenever it raises does a preferential allotment or a private placement, opening a bank account is, so this is one thing which practically there is an inconvenience, I would say. It's not a difficult task at all, but it's an inconvenience that is being faced. But never mind the regulations, we as conscious keepers of the regulators regulations and the compliance
because nowadays
issues.
the KYC requirements are more strict and it took time to open an account.
So we should also be vigilant in closing down the balance, closing down this once the proceeds are being utilized. That's all. I think that's a easy way to do it.
But it is must to have a open new account actually.
It is
you can't use any ideal account lying with the company.
It should not. We should not use. And precisely that's the reason. These are the things which were not. And it should be only through a bank account. Why you can't give a cash and get away? So the concept of giving cash and doing and getting an allotment has been done away with. So that is another fallout of that infamous thing. Now, as a variant of what do you call, as a variant of the preferential offer in case of a listed entity, you also have what you call as a qualified institutional placement. So this is nothing but again a preferential issue, but the prospective allottees are only the QIBs. That's a qualified institutional buyers as defined in 2Z1D of the ICDR regulations. So again, it talks about eligible securities under a QIP. What it talks about is the equity, and here is a new instrument. I will not say a new instrument, but a combination of two instruments that is being allowed in this. One is the non-convertible debentures along with warrants. Now, whenever a company issues this kind of a thing, it acts like a softener to a sweetener to this entire deal. So it's a advantage, win-win situation both for the issuer as well as for the warrant holders or the NCD holders in this case. So you can issue NCDs along with warrants. Many companies have done this kind of a thing, and it's and again the relevant date in this case vis-a-vis a preferential offer in case of listed entity, or here the relevant date goes back to 2 weeks prior to the date on which the board or the committee decides to open the issue. Again, we might be wondering as to why in a private placement there is an opening or a closing of an issue. Yes, there is a it has been very clearly mentioned, yes, there is an opening of the issue even in case of, but normally a QAP gets filled in maybe within a day or two, the entire process gets over. So I think it's a very good process for such companies which have what do you call where the institutional investors interest are very good, and that is a good route that to take. And QIPs if you can recollect goes back to those days of when all the Indian companies were targeting to raise money from abroad through ECBs and the FCCB routes to just to give them another option of raising money from the Indian sources itself. The QIP was introduced, and it's a great hit, I can say, in terms of the corporates, where a lot of, sometimes in a particular year, the QIPs, the issues or the amount that has been raised through QIPs have are far more than that has been raised through an IPO too. So I think QIPs is also a very good route. And again, the 2013 Act talks about private placement offer. Here it talks about a placement document. Now, in case of, one of the things that we need to be careful about a private placement or a preferential offer in case of a listed entity is there is nothing mentioned in the ICDR talks about certain things about the placement document, what are all the different things. For one example is that it doesn't talk about the, it does talk about the financial statement, but not on the period for which the financial statements have to be stated in the document. So normally what we do is we feel that since ICDR has not defined anything, let's just give it maybe the latest audited financials, but at the same time we also have to comply with Pass 4 requirement, which very clearly talks about last 3 audited figures. Okay, slight deviation, friends. One more thing, you know, if in case of an IPO, if we are marketing the issue abroad, you know, we should also be careful about what do you call about the jurisdiction, what are the requirements under the securities laws of those jurisdictions, especially if you are marketing in United States. There are a couple of you know, under the Securities Contracts Act, sorry, under the SEC regulations, there are 2 things. One is on regulation 5A, and the other one, the Reg S, what we call as the Reg S, and section 144 issue, where Reg S is basically outside of US. If you are marketing, what you should do, and if you are doing it in states, what are the implications. That's why you have a lot of international councils advising you on this aspect. And even in fact, when you draft an offer document in case of an IPO, it is the international councils who literally facilitate and help us in drafting the business sections as well, because they are in a much better position to advise us on what is the exact the regulatory requirements of that country. One of the things I'll tell you, friends, is financial statements. When I mentioned in the IPO, we need to have for the last 5 years, and the audited accounts cannot be more than 6 months old. That's one thing which we need to be careful about. Now you open an issue, and you know, and again under the US, normally the period is not even 6 months, it is 135 days. So let us also be careful. So there are 2 double requirement. If you want to market it, you abide by this 135 days. If you don't want to market it, you have a breadth of 180 days to do this issue. So that's a small piece of information that I wanted to share. So this is on the IPO side, and even on the preferential side, this is a thing. But I would advise, friends, there are a lot of companies who without getting their equity shares are also getting their NCDs listed on the exchange, either through private placement basis or through the IPO route as well. So there is a different set of regulations that are governed, which are governing this issue of debentures getting listed on the exchange, and that paves way for, and there the rule 19B is totally exempt even if you do an IPO. But in terms of whether you need to, one of the major thing is you need not file any DRHP or a RHP, or it's only the prospectus, draft prospectus, and what we call as the prospectus that are filed only with the exchange. A copy is being served on the SEBI, is being served on SEBI. So it is the exchange that gets into the details, but the entire document, if you see, more or less 90% is replicated what do you call in a public issue of equity shares, in the sense we cannot get away from section 26, because ultimately it is also a prospectus under the Companies Act, and that's the reason, friends, though you are doing, don't just rely only on the debt issue regulations of SEBI, but you need to also to be careful about section 26 of the 2013 Act read with its corresponding rules. So almost the entire thing would become, but only thing, since it's a debt issue, certain things in terms of materiality, in terms of disclosure requirements, we can always in consultation with the merchant bankers, we can take a call into as to what can be disclosed and what need not be. What need not be disclosed is one thing which there is one peculiar thing which especially the companies in the financial services are issuing. It's an instrument. The instrument is nothing but non-convertible debentures, but it is issued in the form of a structured product.
Okay.
Okay. Now it's a structured product. Now what is a structured product? Is nothing but I devise a product to suit your requirements. But ultimately it is nothing but a NCD. A typical NCD, what we call as a plain vanilla NCD, has a fixed tenor and a fixed rate of coupon rate to be paid over a period of whatever installments or a year, whatever you agree, and you repay it at the end of the term. But in case of a structured product, it works like this: no coupon rate is fixed, but you are eligible to participate at the time of redemption on the upside of what is being given. For example, today I issue NCDs and it is being linked to a particular benchmark, say a BSE Sensex or a NCD Nifty index. Okay, depending on the movement of Nifty index or the BSE Sensex, whatever the upsides that I am going to get after 2 years or whatever the tenor of the instrument, I am eligible to participate in it. So if you are risk taking, if you have the risk taking ability, normally the institutional investors and the HNIs do subscribe. That's why the minimum ticket size is kept at 10 lakhs, and for NBFCs it's at 25 lakhs. It's been kept at that stage. So the lot of huge, there is a great demand for such kind of product, but just wanted to keep our professional friends aware of an existence of such kind of instruments, and that's the reason SEBI has also come out with a separate guidelines for structured products as well. There is a plethora of things that needs to be complied, nothing great, but yes, when you do a structured product, let's not get baffled by this term. It's nothing but clothed in the form of a NCD, because ultimately in the financial statements it is getting reflected as NCDs. But yes, I wanted to just to give a word of thing. In between, can we take some questions?
Yeah, there is one basic question which generally comes into the mind of the people. This is regarding the common difference between the private placement and the preferential allotment, because at both the places we talk about the offer being given to the limited group of people or limited category of the people, and then how we need to define or differentiate between the private placement and the preferential allotment.
I think it's very simple. If you look at preferential, there is a specified securities that had been or the eligible securities that have been mentioned in section 62 rules very clearly talks about equity shares, and those instruments that are convertible into equity will fall under the section 62, whereas under 42 I can issue a NCDs as well. That's the reason section 42, if you read with section 71, when you issue non-convertible debentures, you are taking an omnibus approval at the beginning of the year by passing a special resolution for issue of NCDs, which was never heard of in the 56 Act. Now it's a very clear. So I think that is the basic difference when you talk about a preferential offer under 62 vis-a-vis a private placement under section 42.
Again, at the time of private placement, we need to identify the actual name of the people and their contacts to whom we are going to allot the or to offer the shares. But in case of preferential, I think that requirement is not there. There is one more question relating to the renouncement of shares, whether renounced shares can be allotted by the board to any other person if the renouncee does not accept it.
The renouncee
does not accept.
It very clearly says that the board has a right to, which is not disadvantageous to the company. If you read section 62, it says not disadvantageous to the company. If it is so, yes, it can. The board has got the right to do it.
There is one generic question, whether equity shares can be issued at discount.
Whether
equity shares,
section 79 of the earlier 56 Act permitted issue of shares at a discount. Now that is being prohibited under section 53 of the new Act, and hence any issue of shares shall be void.
There is one question relating to right issue. In case of an right issue, within how many days the company need to allot the shares?
There is actually, if you look at even unlike what I mentioned in T+6 for a listed entity, there is nothing even in case of a what do you call a listed space. So the Act doesn't provide you for a allotment of, but normally we should take a clue from, in case of a preferential, if it is to be done within a period of 60 days, why can't we take a clue and also do it within a rights within. And when in case of a rights issue, when the board has also got the powers, as one gentleman asked about whether the board has got the power to allot the unsubscribed or the renowned shares, when it is not disadvantageous, I think the board should very quickly within a reasonable period should start acting on it and allot the shares.
Great. Ranganathan, I think I am getting lot of questions looking at the burning topics we are handling here.
We'll take few.
Yeah.
We'll take few.
In case of preferential allotment, whether it is compulsory to comply with section 42?
I think it's very clearly written that it has to be read with section 42.
Okay.
Both, it has to comply with both requirements. It has to comply with both requirements.
This question we have already discussed, whether right issue requires opening of a separate bank account in case of a private limited company. So I think that is not. While an offer document pass 4 is issued by a company where the shares are yet to be allotted, can a company offer shares through right issue before completing such allotment?
So there is very clearly, it talks about where unless the first allotment is completed by
Yes.
any means, whether it's a private placement or rights issue or XYZ route that it has been, then you cannot of the
Make an offer any second
thing. I think first you complete the allotment of a particular security and then get into the allotment.
or need to be withdrawn or call back.
Call back, yeah, of
Yeah.
course. That activity should be complete in all respects.
True, true. Please. Continue. It's over.
Over, yeah. One last thing which I just wanted to mention in terms of where Indian corporates have been going and raising money from abroad through FCCBs and other thing. Now the latest trend is in the last 1 year has been what you call as masala bonds, which I just wanted to mention, which is nothing but it is unlike in an FCCB, a masala bond issue is designated in Indian INR and it has to be repaid only in Indian INR. So the exchange risk is on the investor rather than on the Indian corporates. So that is one of the major avenues that has come to the corporates for raising money from channels abroad. And of course, for a NBFC, similar to a bank which can issue perpetual bonds, even a NBFC can also issue a perpetual bond, but there is though we call it a perpetual bond, there is a time limit of a 10-year period, after which with the approval of RBI it can redeem those bonds. Just wanted to give a flavor of the other kinds of instruments which are sectoral specific or maybe which the corporates can take advantage of it.
Okay. There is
And
one.
masala bonds, whenever you are issuing, none of the provisions of the Companies Act is applicable to it. But it doesn't mean that you can't even satisfy section 181C where it talks about the borrowing powers. At least let's ensure that that is in place, but none of the other sections or limits of a Companies Act is applicable to them.
Right. Can you just advise about the, if a company wants to come out with the ESOP policy and at that time of approving the scheme, there is no space into the authorized capital and the paid up capital. So whether that company can very well come out with that scheme or they need to first increase the size of the capital, even though the exercisable period from the date of adopting the scheme is at least 4 years after that.
It's a very what do you call neither a grey area nor an easy question, but at the same time as professionals what we have to take care of at the beginning itself is that now you are issuing an instrument,
Yes.
which ultimately you are going to convert or maybe which takes the avatar of an equity in some time
After some period of time.
So you very well know in advance that this is going to happen. So
Okay.
why don't you increase the authorized share capital? Yes, the only argument that you and I will face from the management is that there is a cost involved to it. Why should I
Do it right
but
now.
do it right now? But in all probability that means you are going to the shareholders and taking an enabling approval for something what do you call, for issuing or for granting of options, which ultimately gets converted into equity if you exercise, but you do not have a underlying capital adequate enough to do that. One can argue that just before the exercise, when I allot, I will increase my authorized share capital, but that is not the real intention of the authorized, that is not the intention.
So operationally that can be challenged, but I think legally it is okay.
Legally there is nothing.
Nothing.
There is nothing.
Okay, great. There is one question relating to the offering of the private placement, that is the rule is rule 14(2)(b) is there. It's saying that in an year, aggregate financial year, you cannot offer to more than 200 people.
Yes.
So let's say if company has done with the 3 private placement during the year, first time they have offered to the 100 people and 30 had come turn around, then to the 50, then to the 30. Now they have, let's say, almost offered to the 200 people, but hardly 50 people has turned around. That company is again having some offer for private placement for equity investment, but they have exhausted with the limit of the 200 people.
Absolutely. As I mentioned here, let us not go with the prospective allottees who have ultimately been allotted the shares. It is the number of people to whom the offer has been made or the invitation has been made. Rather, it is an invitation to those buys. So it is, and that is the reason PAS 5 is very clear, saying that you compare with the register which you had maintained to whom you have whom you are going. Why do we have it in the explanatory statement very clearly stated that the ultimate what do you call, the prospective identity of the prospective allottee should be stated. That means you know very well that this guy is going to subscribe, and that is why you compare this register with the PAS 5 register as well. So it goes with the number of people to whom you have offered.
Right. And again the internal limit is that the offer of private investment to maximum 50 people, and that is excluding the qualified institutional buyers and the employees quota.
Yes,
that too under the ESOPs. So we do have any questions, because most of the questions has been highlighted and we have been responded by Renganathan already there. Anything you want to highlight more on this?
Let me.
Something on, if you can guide on the practical aspect, like if the company or the promoters are having the investor before them, now what is the easiest way to have the investment, whether it is in private placement or the right issue or the preferential allotment, easiest or the economist way?
Easiest, say, first and foremost
from the company's perspective or the promoter's perspective.
So it all depends on, first and foremost is from a case to case basis.
Right.
Secondly, what is the time period that you are envisaging to get the money?
I think promoter would like to have on the very earliest stage.
Very early stage, right?
Yes.
So there is no concept of a QIP in a private level, in an unlisted space. So if you are in a listed space, I would prefer that QIP is a better option, because at least the institutional investors will understand this company and they will be in a far better position to subscribe to your shares very quickly. As I mentioned when I was talking about QIP, the process takes the moment you identify, I think it is a question of a day or two, the money also comes into the coffers. So that is, I would prefer that, that is a easy route. Of course, preferential allotment, though there is a placement offer under the PAS 4, under the QIP, you have a placement document. But I would prefer QIP will be a better proposition. This is my view.
QIP is a better way.
But of course, QIP for an listed entity, it all depends on facts of each case. One more thing in an IPO which I just wanted to highlight, we all might be thinking that a lot of projections can be given in the financial statements, but friends, no projections can be given in the financial statements in case of an IPO or in a QIP. So very clearly projections have to be cannot be given. Let's understand very clearly about projections not to be given in a draft or DRHP or a RHP or a prospectus.
Okay. And one question I would like to have a clarification from you as an expert. When we are talking into the private placement as a limit of the 50 people, excluding the employees of the company and the qualified institutional buyers, if you are talking about the company, whether the company means the literal interpretation of the company only, or can we include the employees of the subsidiaries or associates also?
No, whoever it is being ESOPs, if you look at to extend our question, ESOP can be offered to the employees of the holding company or the subsidiary company if the holding company is offering.
Okay.
Okay. So everything will be falling under the ESOP category. So whatever is ESOP, if you see very clearly, so if you see the regulations, now we have the share based benefits regulations, it can be offered to the employees of the subsidiaries companies and also holding companies. So everybody will be out of the purview, and you also possess separate resolutions for them, for the holding company, for the shares of the company that you are issuing, and for the other subsidiaries that you are issuing. So in my view, it includes everybody. You can't, just because I have issued to ESOPs have been granted to my subsidiary employees, they should be counted. No, in my view, ESOP is a ESOP, and whoever is the eligible investors in ESOP will be outside the context of section 40.
Basically, we need to see the scope of the ESOP policy, whether the company has included the subsidiaries also,
Absolutely.
or whether the company has included associates also.
That's the reason I am emphasizing, whenever a company passes any resolution, if you are going to grant options to the subsidiaries, we need to have a separate resolution passed for that also.
Okay, great. So, Ranganathan, I think we have covered up with almost entire areas, and we have touched the entire points over the topic and the 4 ways of the issue and allotment of shares what was awarded to this particular 16th session of the webinar. Very much thankful to you on behalf of the institute. I Praveen Soni, very much thankful to you institute and the moderators of this program, and Mr. Ranjit Pandey and President Mr. Shyam Agarwal for encouraging this kind of programs, so that the people on throughout the each and every corner of India can see and have value additions into the professionals, and they can learn from the professionals, those who are staying or located into various parts of the India. So I think this is really a good programs and good unique developments of the.
So that's what, even once again I thank the institute for giving me this, to be a part of this intellectual journey of we professionals, and more and more such kind of webinars and such sessions should be encouraged, so that we need to get at least a broad insight, though we may not be directly handling the things on a day-to-day basis, but at least as professionals we will be equipped with adequate knowledge, so to face the corporates or the challenges that the corporates are throwing in.
Thank you. Thank you. We will be closing it with a good remark and a small token of sapling to you from the institute side. Thank you so much, Ranganathan.
Thank you.
Thank you. Thank you. We have covered the session on within due time only. Thank you very much.
Thanks.